Hi everybody, thanks for tuning in. This is a new motion to dismiss filed by Harvey Adelson's attorney in the Fair Labor Standards Act lawsuit, filed in February of this year by someone named Danny Tijero. Tijero was a maintenance man for at least one of Adelson's properties, and he claims he was fired back in July 2022. Harvey Adelson claims Tijero was not terminated, but rather he quit, but that's not the issue. This motion to dismiss has to do with whether the lawsuit should just be thrown out. Adelson's lawyer Gary Cohen argues that the lawsuit should be dismissed because he does not have a claim that would be covered by the Fair Labor Standards Act. So I'll just scroll through this and hit some important notes here. The plaintiff claims he worked in excess of 40 hours per week and didn't get overtime. However, he doesn't have documentation as to what hours he worked or what's legally due. According to this motion, the plaintiff also does not show that he's covered by this federal law. This is what I pointed out in the previous videos on this lawsuit. The plaintiff has to show he was engaged in interstate commerce. The motion argues that Mr. Tijero simply using a credit card to purchase a washing machine is not interstate commerce. I agree without doing any legal research on this topic. Plus, Danny Tijero doesn't have documentation or calculations. He was just claiming that Harvey Adelson and his corporation had over $500,000 in revenue a year with no documentation. But some of these arguments, if in dispute, seem more suited for a motion for summary judgment, which would be filed later after doing some discovery, which could include depositions, interrogatories, requests for documents, and/or requests for admissions. Adelson's attorney is saying Tijero has no cause of action and there's no subject matter jurisdiction. These are statements of the rules of civil procedure. Defendants argue that Mr. Tijero has failed to allege amounts owed, rate of pay, and hours purportedly worked in excess of 40 hours per work week. He just made up numbers with zero documentation to substantiate them as required. He says he never clocked in out of work, says he was paid with cash without pay stubs showing information about the actual hours he worked and the rate of pay. Here, Harvey Adelson, through his attorney, claims that the plaintiff was never paid in cash, all by checks. But again, that's something that seems more appropriate to bring up in a motion for summary judgment, because that is a point in contention. Anyway, he's saying that the plaintiff's allegations are inconsistent. Therefore, the complaint should be dismissed. This is also something that I agree with. Tijero claims that Harvey Adelson could track the number of days and hours that he worked, but yet he concedes that he never clocked in and out of work, so how does he expect anyone to be able to figure out what amount of overtime hours he worked, if any? Adelson says the complaint has been filed frivolously. In his complaint, Tijero said that he could use his own recollections somehow to figure it out later. The plaintiff doesn't have to include all his proof with his complaint, though. He can do that later by providing some sort of documentation if he has anything. Then Harvey Adelson argues what I was wondering too. If Tijero were a maintenance person, how was he engaged in interstate commerce? He was working for some rental property. Did he use instrumentalities of interstate commerce in his work? Adelson's motion lists these requirements for the Fair Labor Standards Act to apply and says plaintiff doesn't meet the requirements. He worked at a confined property in Broward County, Florida, and doesn't document those alleged unpaid amounts sufficiently in his amended complaint. The complaint is made up of vague, conclusory, and insufficient paragraphs. Plaintiff received 1099s as an independent contractor. Just making up numbers as estimates doesn't meet the standards of FLSA. This is where, again, I believe these arguments are more appropriate in a motion for summary judgment because whether Tijero was an employee versus an independent contractor is in dispute. A motion to dismiss has to do with whether the plaintiff's allegations are not even sufficient to state a legal cause of action. Then he ends this section stating, lastly, Mr. Tijero was never fired, he quit. This I find kind of funny because usually in legal pleadings you don't have exclamation points. Obviously there is a controversy as to whether Tijero was fired or quit, but ultimately this isn't some sort of wrongful termination case, so it doesn't really matter in this case. Okay, so that's pretty much it. The rest of the pages are certificates of service, just indicating that the attorney provided a copy of the motion to the plaintiff's attorney. This isn't horribly exciting, but people who are really interested in the entire Dan Markel and Adelson case or issues pertaining to labor law could potentially find it interesting. Usually when I use these artificial narrator voices to help read, people complained, but people complain even more when I read using my own voice. I'm still having vocal issues and trying to get medical treatment, so thank you for sticking with me and still tuning in. I'm watching some of the Chad Daybell trial, but don't have much commentary to add. Other than that, I think he is guilty and the prosecution is presenting an excellent case against him. As for the Karen Reid case, I haven't read a lot about it and would be interested in hearing her defense and want to keep an open mind. Next weekend, I will premiere a new version of last year's Donna and Wendi Adelson Wheel of Fortune parody video. The panic attack music I had previously used became copyrighted, so I had to edit it out and put in new music and dialogue. Have a great week and thanks for tuning in.